Hey there, estate planning attorney Paul Rabalais here, and in this video, we're going to talk about whether you should have a will or a trust, or maybe something in between. So there's been lots and lots written discussed about whether you should have a will to leave your estate to your heirs, or whether you should have a living trust to leave your estate to your trust beneficiaries. The proponents of the trust typically say something like, yeah, you should set up a trust, transfer your assets that are in your name, also referred to as your probate assets. Transfer your probate assets to your trust. Assets that are in your trust when you die, they're not frozen like assets in your name are. And assets in your trust, they don't require lawyers and judges in order to get the assets transferred to the trust beneficiaries. You simply create your trust, you name a successor trustee of your trust, who, when you pass away, will have the immediate authority to access those trust assets and distribute them to your trust beneficiaries that you named, all outside of the court system. Sounds like makes sense, seems to make some sense. Now, the proponents of the will typically say, you know what, probate's not that bad. Let's keep things simple, just leave everything in your name. We'll get your will prepared to make sure your assets go to the right people, and you can name your executor who's going to be in charge of your probate, but let's keep it simple by leaving everything in your name. We'll get your will done. Sure, when you die, there's a probate required, but it's usually not that bad, and quite frankly, it's often the attorneys who make their living from helping their clients through the probate are the ones who typically kind of take the position that you should have a will because probate's not that bad. Plus, and there's some merit to this argument, the will proponents say, don't dare get a trust and then die with an asset in your name. That will render your trust useless, because if you have a trust and your trust is not what they call fully funded, if everything in your name has not been transferred to your trust when you die, and there's one asset in your name, then that renders the trust useless, because now a probate is required because you had an asset in your name when you died. So really, what's the reality here? Well, let's take a much closer look and maybe talk about what I'll call a hybrid approach. So the trust proponents are correct. Assets that are in your trust when you pass away, they do avoid probate. If you have $1 million brokerage account and you have 4 heirs or 4 beneficiaries, and that brokerage account when you pass away is in your living trust, then typically within days after you pass away, that successor trustee that you named, maybe you named the responsible child as the successor trustee of your trust. Of course, you're the trustee while you're alive. And within days after your death, that successor trustee will gain access to the account, and then we'll distribute that account to the 4 beneficiaries equally, all without any court and lawyer involvement. So that sounds pretty simple, because quite frankly it is. However, if you die with $1 million brokerage account that's in your name when you die, and you have a will naming your responsible child as the executor of your will, and you name your 4 children as your heirs in your will, then when you die, that $1 million brokerage account is going to be frozen. And then your executor and your heirs must hire lawyers and go through the court process. They'll likely be delayed by months, if not years, gaining access to that account through the court system. So now I will say the will proponents are right, because there will be a probate even if you have a trust, but if it's not fully funded, you have 6 assets in your name, 5 of them you transferred to your trust, 1 you didn't, there will still need to be a probate to get that one asset that's in your estate, that's in your name, out of your name. The family will have to go through the probate process to get access to that. So what do you do? So I'm here to say it's not necessarily an all or nothing approach. And let's talk about what I call, never heard it called this before, but I came up with a name that's kind of the hybrid approach. And I'm here to tell you it's not a disaster if you set up a trust, transfer most of your assets to your trust, but still, when you pass away, there's some assets in your name. Let me give you an example. Let's say mom dies having established a living trust, and when she establishes that trust, she transfers the big stuff to her trust. So her home gets transferred to her trust. Her $1 million brokerage account gets transferred to her trust. Her savings account, she goes to the bank and she retitles her savings account to mom as trustee of the mom living trust. So when she dies, there's, let's call it $1.5 million of assets in her trust. Well, because her home is in her trust, the day after mom dies, the trustee, successor trustee, puts a for sale sign in the yard, sells the house, distributes the proceeds to the beneficiaries. Literally within days after mom dies, it will likely require a death certificate of mom, but at that point, then the successor trustee can then disperse the trust assets to the 4 beneficiaries. Same thing with the savings account. So within a very short period after mom dies, that $1.5 million of assets gets transferred to the 4 beneficiaries. Everybody gets $375,000. The pressure's off. Everybody's kind of happy. They're sad that mom died, but they're happy the estate is getting settled correctly. However, there are still assets when mom died that are in her name. Either because when she set up the trust, she just neglected to transfer certain assets to her trust, or she acquired assets years after she formed her trust, but before she died, she forgot, she neglected, she didn't, life got in the way, and she acquired those assets in her name. So when she died, there was a vehicle in her name. There was a money market account at the brokerage firm in her name. There was some shares of stock still in her name. And perhaps even there was a refund check after mom died from the IRS, from the assisted living facility, payable to estate of mom. And the only way to get access to that is to go through the probate process. And let's say those assets in mom's estate when mom died were worth $100,000. So what's happening here is the 4 trust beneficiaries, who are also mom's heirs, they got $375,000 apiece pretty quickly, because there was $1.5 million of assets in mom's trust divided 4 ways. Let's say within a couple of weeks after mom died, or within a month, everybody got their $375,000, their 1/4 of the $1.5 million. But it's going to take a while to go through the probate process, because mom also, in addition to her trust, she had a will. People who set up living trusts, those wills are typically, kind of slang term, it's a pour over will, because mom's will says if I do die with anything in my name, I pour it over into my trust. And so those assets that are in mom's estate, that $100,000 of assets, the vehicle, the money market account, the stock, maybe even a refund check payable to mom's estate, those all have to go through the probate process to get transferred to mom's trust. So then those assets later can be transferred to the 4 trust beneficiaries. But if those 4 beneficiaries have to wait months or even years to get access to that $100,000 of assets, or $25,000 a piece, not a stressful situation, because the trust beneficiaries already got $375,000 a piece. Yes, they'll have to wait months, maybe years, to get their remaining $25,000, but the pressure's off. They got the big chunk immediately, because that is what was in the trust. In addition, what I like about the hybrid approach of having a trust, having some assets in the trust, but having some assets for whatever reason in an estate, is that under that scenario, that probate is going to be much, much simpler for 2 reasons. One reason, there's fewer assets involved in the probate. But the real reason that probate is going to be simpler under this hybrid approach is because there's only one participant in the probate. Because mom had a will, she named an executor. Let's say she named a responsible daughter as executor. And so that's the executor of mom's estate. And mom's pour over will left what was in her estate to mom's trust. And responsible daughter is the trustee now of mom's trust. So responsible daughter is the only participant in the probate, because responsible daughter is both the executor of mom's will and is the trustee of mom's trust. The probate process moves the assets from mom's estate to mom's trust. So there won't be 4 children, 4 heirs that are participants in mom's probate. The more participants that are involved in a probate, the more likelihood for bad things to happen that require delay and lawyering up and all that stuff. Because if you have 4 participants in a probate, there's a chance one of them might, not be fully cooperative, not be willing to sign off on all the court paperwork, and that's where things slow down and that's where disasters happen. But when you have someone who has a living trust with a pour-over will, and the executor of the will is the same person as the trustee of the trust, then the probate only involves one person. It makes that probate process as simple as it gets. So this hybrid approach happens more than you think, because people will create a living trust and intend to make sure that when they die, every single thing that they own is in their trust. But then life gets in the way and they die with many assets in their trust and some assets not in their trust. That's not necessarily a disaster. It's really a recipe for all of the trust beneficiaries, being kind of content. Sure, they're grieving their mom died or somebody passed away, but that stress of heirs and beneficiaries waiting and waiting and waiting, and then starting to lose trust in the people who are involved in this, whether it's the lawyers or the executors or the trustees or the accountants or the court system. That stress that builds up from the time mom dies, and the heirs are just waiting and waiting and waiting, and it's stressful, and that's where relationships start to break down. But when there's a trust that owns most of the assets that can be dispersed immediately, that takes the pressure off, even if there's a delay to have the probate done on those remaining estate assets. So that hybrid approach happens a lot. If your parent, for example, passed away, don't necessarily consider it an all-out disaster because your parent created a trust, but there's still a probate required for some assets, because that probate's going to go quicker, only one participant, and if there are any assets in the trust, you're likely to get those much quicker than you would if you had to wait on the probate to gain access to that. Okay, hope that helps. Just remember that hybrid approach. We'll see you next time.